Welcome to episode 49 of Call to the Bar, International Law Over Drinks. I'm your host, Ntina Tzouvala, and I'm an associate professor at UNSW Faculty of Law and Justice. Today, I'm joined by Dr. Margaretha Wewerinke-Singh. She's an associate professor of sustainability law at the University of Amsterdam and co-founder of SEVEN, the university's climate institute. She's also an adjunct professor of law at the University of Fiji and a member of the Permanent Court of Arbitration in The Hague. I'm also joined by Mr. Dylan Asafo. Dylan is a senior lecturer at Auckland Law School, and he's also currently a PhD candidate at Melbourne Law School. Dylan's primary areas of interest include race and the law, climate justice in the Pacific, constitutional and human rights in the Pacific, and criminal justice, as well as abolition. 2 weeks ago, in episode 47, we were joined, as you might remember, by Dr. Juan Ouz, who discussed the advisory opinion of the Inter-American Court on the climate emergency and human rights law in the Americas. Today, we're discussing another, more high-profile advisory opinion related to the climate, the much-awaited opinion of the International Court of Justice. Before we dive into the detail with today's guest, I once again want to remind everyone that in these informal conversations, we're always speaking off the cuff and without the benefit of footnotes. And nothing we say should be taken to have been thoroughly peer-reviewed. First off, that is our traditional question, Margaretha and Dylan. What is your drink? Margaretha?
I'm having a delicious green jasmine tea.
Fantastic. Also, I have to say it's quite early in the morning where Margaretha is at the time, so that sounds only sensible. Dylan?
Yes, I really wanted to have something fancy like a martini for this podcast, but I'm making do with sparkling water with lime, which is all good.
That also very sensible. And I'm having peppermint tea. It's 7:15 in Sydney, but I'm nevertheless trying to be sensible. So before we get started, we usually ask our new guests to talk a little bit about the career paths. But I particularly want to hear about your career paths, because one of the reasons we have you today is that you're not only academic experts, but you were also actively involved in the proceedings that led to the advisory opinion. So can you talk to us a little bit about your career paths and how did you find yourself at The Hague advocating in front of the International Court of Justice?
So my path into a career in international law was a bit unconventional, I guess. I first came across international law when I learned about TWAIL, Third World Approaches to International Law, in my first year of law school, where they gave us a crash course on critical legal theory, and thankfully TWAIL was included. And so TWAIL work has really captivated and resonated with me and guided my career path ever since, including to the ICJ proceedings. I came to be involved when I presented a few TWAIL-inspired papers at a Pacific Studies conference at the ANU, and some amazing folks who would go on to work for Blue Ocean Law just happened to be in the audience, and we connected. And so jump forward a bit, when it came to the state of the Cook Islands needing a lawyer for the proceedings, those folks helped put my name forward. And I think the idea is that they trusted my politics and my heart for climate justice in the Pacific. And so, yeah, through that, I was very grateful that the Cook Islands appointed me.
That's fabulous. And it's also, I think, an interesting way of answering, a question about whether TWAIL and other critical approaches are also practical, right? They're usually seen as far removed from the practice of international law, but I think at least your experience points to precisely the opposite conclusion. Margaretha, how about you?
I initially studied anthropology and philosophy and only converted to law after doing a master's in human rights at the European University, Inter-University Center for Human Rights and Democratization in the beautiful city of Venice. I did my law degree in the UK, and after that pursued a PhD at the European University Institute in Florence. And during my PhD, which was on state responsibility for climate change from a human rights perspective, I started working with various groups in the Pacific and got connected with the University of the South Pacific. And that's where I took up my first lectureship after completing my PhD. Quite soon started working with the Government of Vanuatu. 2015 was the year I joined. It was also the year when Cyclone Pam hit Vanuatu. It was the year the Paris Agreement was adopted. And so really, one thing led to another. And I started getting involved in a way in this case as the case itself developed, and ultimately was asked to be lead counsel for Vanuatu together with Julian Agon at Blue Ocean Law.
That's fabulous. And actually, my next question was directly linked to what you alluded to, Margaretha, now, which is I was wondering if either of you could tell a little bit to our listeners about how these questions on climate change ended up on the dock of the ICJ, right? Because this was very much a grassroots initiative from some of the most impacted people on Earth when it comes to climate change. So if you could tell us a little bit more, who started this initiative? And in a sense, what were their hopes when they decided to turn to the International Court of Justice?
So this effort to bring climate change to the ICJ really began with students from the Pacific Islands at the University of the South Pacific, who later organized as the Pacific Island Students Fighting Climate Change. And it was them who persuaded the Vanuatu government, first starting with Vanuatu's foreign minister, Ralph Regenvanu, that an advisory opinion from the ICJ could be helpful, and that it could clarify the duties of all states towards those most affected, and also the legal consequences of breaches of those obligations. So Vanuatu took it up, built an alliance, ultimately of 132 co-sponsoring states at the UN. And the hope was probably twofold for both Vanuatu and for the youth who started the campaign, to confirm that the Paris Agreement is not the sole kind of yardstick for judging state conduct, and also to give courts, negotiators, and other actors a much clearer map of what international law already requires, but also what it has already required for a long time, and so what amounts to breaches of obligations that could then also give rise to entitlements to reparations.
Fantastic. Yes. So very much a grassroots effort. And it's also really interesting to hear about the University of South Pacific being such a center of like activism and thinking about climate change and about law, right? Like I think for a long time, because partly of like structural adjustments and underfunding of universities, especially in the global south universities have been marginalized as like centers of thought and action, and like global action and thought about such important issues. And I think it's so important to see this connection in this instance. Dylan?
Yeah, that's a brilliant point. I couldn't have put it better myself. I guess just to add on to what Margaretha said about how these proceedings came about, I think generally for the Pacific and the wider global South, this turn to international courts and tribunals like the ICJ comes largely from the continued failure of the UNFCCC COP process to deliver climate justice after almost 30 years. And this was something which was openly expressed by states, including Vanuatu, and the climate change minister, Ralph Regenvanu, telling the court that they had just returned back from COP29 in Baku, which showed the failure of the process yet again. So I think, more broadly, the hope of Pacific states and Pacific peoples and peoples of the global South was to disrupt that status quo, which has allowed major emitters to evade their obligations and continue their destruction of the climate system.
Right. I think you're making a great point here in the sense that very often you hear this argument, oh, litigation is not the best way of tackling climate change. And I would say probably Pacific peoples know that better than anyone. Like it is true, it's a suboptimal method, but it's because all the other methods have failed. And I think it's particularly enraging when you hear this argument being advanced by those who have undermined the other better diplomatic and treaty making methods, right? It does feel very much like, a desperate move in some ways, but also I would say a hopeful move. But yeah, a move that comes after other legal or diplomatic means failed. So let me get us into the substance of the advisory opinion. As a reminder to our listeners, the first question that the General Assembly posed was, and I'm quoting, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? So this was pretty much an open-ended question in its framing, essentially asking the ICJ to identify all relevant areas of international law that are important for climate change. There were significant disagreements between states, even about this fundamental question. For example, a number of rich states, and notably Australia, where our podcast is based, tried to argue that the only applicable law was that of specialized climate treaties, in particular the UNFCCC, the Kyoto Protocol, and the Paris Agreement. Our listeners might have heard this being described as the lex specialis argument. Could you quickly explain this argument for the benefit of our listeners? But more importantly, can you tell us how the court dealt with this argument?
Yeah, so on the first question, several many industrialized states, including Australia, had argued that the UNFCCC, the Kyoto Protocol, and the Paris Agreement constitute a self-contained lex specialis. And so they really invited the courts to treat broader customary duties, such as the obligation to prevent transboundary harm, relevant human rights norms, etc., as either suspended or satisfied once a state files an NDC, a nationally determined contribution, under the Paris Agreement. And so the court rejected that view in the clearest possible terms. It recalled its Nicaragua jurisprudence and stressed that treaty and custom retain independent existence and must be interpreted together rather than hierarchically. And it noted that a state that complies with the climate treaties suggests, but does not guarantee compliance with customary obligations. And here it also stressed, as then Judge Plady stressed once more in his separate opinion, that the court here is talking about compliance with the climate treaties as interpreted by the court. And then conversely, a breach of the treaties would essentially evidence a breach of customary due diligence.
Fantastic. Thank you, Dylan.
Something that I think is really exciting to note about the court's rejection of the lex specialis arguments is that it made clear when it was listing and going through the applicable law that its overview is not without prejudice to other rules of international law that may also be relevant. For example, rules in international trade law, international investment law, and international humanitarian law. And that's quite a profound feature of the opinion because the main climate treaties don't clearly refer to those kinds of regimes and their treaties, but the court was very clear that these laws can very much apply to regulate states' conduct in respect of climate change.
Right. Yes, absolutely. Even though the court did not really discuss in much detail this international, especially economic law stuff, it nevertheless said that, these regimes continue to apply and that it basically, in a number of cases, the court was like, well, and we will hash out the details if you actually bring a case in which you allege a particular violation, right? That seemed to be a repeated pattern. So I want to take us a little bit to discussing the climate treaties, right? Because even though the climate treaties, the ICJ said in no uncertain terms, they are not the only applicable legal framework when it comes to climate change. There is no doubt that they are particularly important, right? And at least in my eyes, one of the most significant aspects of the advisory opinions, or the opinion, excuse me, was that the court reaffirmed the the 1.5 degree increase in comparison to pre-industrial level is the primary target for climate action, especially under the Paris Agreement. Do you agree that this emphasis on the 1.5 was important? And if you think it was important, why would you think so? Both in terms of law, but also in terms of like real life consequences, for example, further litigation or political pressure or anything else that might come out of this advisory opinion. Dylan, do you want to?
In terms of law, I think the court's reaffirmation of the 1.5 goal is really important in making clear that the Paris Agreement isn't dead and gone, as many major emitters have, been pretending it is. And in terms of real world consequences, having the court, I think, essentially breathe new life into the 1.5 degree goal was absolutely essential because states' current collective ambitions are inadequate to keep warming below 1.5, and we're well on a pathway to 3 degrees by the end of the century. And what was also really important was that the court cited the IPCC's report, which stated that even at 1.5 degrees warming, conditions won't be safe for many communities. And we know that's especially the case in the Pacific and the wider global south. And in terms of real life consequences, that's why Pacific and other SIDS and activists have been championing the 1.5 to stay alive slogan and campaign because it's very much true. Every incremental increase comes with more death, with more displacement, loss of land and loss of cultural practices and traditions and knowledge. So the importance of the courts reaffirming the 1.5 degree goal can't be overstated. It was desperately needed.
Absolutely. Margaretha?
Yes, I very much agree with all of that. I'd add just two things. One is that the 1.5 degree limit is crucial, but of course should not be equated with compliance with all relevant obligations. And again, it's Judge Tladi who, in his separate opinion, stresses this point, I think, very insightfully, pointing out that under customary international law, 1.5 may not be enough, essentially, or customary international law, to be more precise, may require more than aligning actions with 1.5. And then the second point is the temporal dimension. So 1.5 is a limit that in today's world already, unfortunately, even seems difficult to achieve. But that is only because of continuous breaches with obligations. And that is, of course, something that the court does not make explicit in its opinion, but the opinion can be read as compatible with that understanding. And so the temporal dimension is critical here. So what the court states in the first kind of general part of the opinion about the temporal scope of the opinion is that compliance with obligations must always be assessed in concreto, and there it is important to look at obligations and conduct over time. And so that means that at one point it would have been very possible to stay well below 1.5 and would stay below 1, but it's only because of conduct that resulted in these cumulative emissions that now have put us in a situation where we're looking at 1.5, 2, 3, whatever it is. But that is not to say that that is all, and that everything that has led to this point should be forgiven or is legally irrelevant. And I think that is an important point to kind of bear in mind as we read this opinion, because it could be read as if it is just about lex lata and we're forgetting about the past and only forward-looking. But that really is not the case. And this is one of those issues where a kind of careful and nuanced reading is really critical to avoid getting kind of unwanted climate unjust consequences along the lines of the finding of the Supreme Court of Switzerland in Clima Signorin, that we can't speak of rights violations because we haven't surpassed 1.5 degrees yet. So just, I'd add that.
Yeah, so you would say that basically, if we read the opinion carefully, what they're saying is in terms of international legal requirement, like 1.5 in a sense is the floor, but there is nothing that precludes the possibility that the ceiling is actually lower than the 1.5, right? That there is legal obligations coming from example from customary international law, from human rights, or from other fields of international law that actually pose obligations and render whole swaths of emissions, past, present, and future, wrongful, essentially. Is that the argument? Do I understand the argument correctly, Margaretha?
Yes, exactly. And in part, it's also because there has been a breach at 1.5 may not be enough. So for some states, especially those that are just starting to add emissions into the atmosphere, and that 1.5 is perhaps enough, but for others, for the historical polluters, unlikely to be because they're already in breach. And so we have cessation obligations also kicking in.
I see. Okay, that makes a lot of sense actually to me. So I'll keep us with the climate treaties, because one other issue that the court tackled was what Margaretha just mentioned, the nationally determined contributions under Article 4 of the Paris Agreement. You're the expert, but just very briefly for our listeners, basically, under the Paris Agreement, states have undertaken the obligation to prepare and share national plans about the reduction of their emissions. The problem that the court faced was that the Paris Agreement as such does not set out concrete targets for each state, and instead leaves them with some degree of discretion in terms of setting out these national plans. How did the court navigate this question, and in particular, how did it navigate the disagreement between different states about what degree of discretion do states enjoy under the Paris Agreement? Like, basically, can states take the piece and just put together a plan that barely registers that there is a climate catastrophe, saying, and provided that they have gone through the motions, they're in compliance?
Yeah, so the court's answer here is really crystal clear. That is absolutely not possible, and so that does away with the question of whether the content of NDCs is regulated at all under international law. And so the court says it actually is. And so discretion is not unfettered. Each party must exercise stringent due diligence. Here the court, of course, draws on the standard that ITLOS set in its advisory opinion, the stringent due diligence. And here the court explicitly said that states must ensure that NDCs, together with the others, must be capable of delivering the 1.5 goal. And so those NDCs are open to objective scrutiny, so that really limits what is nationally determined. So national determination becomes then like a procedural device and can no longer be understood as a shield against a substantive assessment.
And absolutely, and as Dylan said a moment ago, even if states were religiously complying with their nationally determined contributions, science tells us that that would actually lead us to 2.5 up to 3.1 degrees Celsius increase in comparison to pre-industrial levels, right? So we know based on the best science available that states, and especially the biggest emitters, even if they were compliant, which they are not very often, they wouldn't be en route. So they are in violation of the binding agreements, binding legal obligations they have undertaken under the Paris Agreement. Dylan?
Yeah, so just to add in practical terms, this is quite significant because states can now be held to the fire for their inadequate NDCs and have them scrutinized to that stringent due diligence standard, whether in litigation efforts or public submissions processes on NDCs and other advocacy avenues. And I'll just say that in New Zealand, this is going to be quite interesting because a few years ago there was a decision which cast doubt on what's required of government and their advisory bodies with regard to their NDCs and their compatibility with the 1.5 degree goal. And unfortunately, the New Zealand High Court found in favor of the government. But just earlier this year, moves were made to appeal this decision to the Supreme Court, which will hopefully go ahead, because if so, this finding from the ICJ of a stringent due diligence standard for NDCs could have a massive impact. So hopefully the court takes that on board.
Right. So especially about domestic litigation in terms of courts that take into account international law, this aspect of the opinion has the potential of actually bringing about concrete legal outcomes. And even as you say, in terms of administrative processes, right, insofar as there are possibilities for civil society and for climate activists to have some sort of meaningful impact, I think we can discuss how much even supposedly liberal democracies still have any space for meaningful effect on policy. But insofar as these processes still minimally work, now people, activists, citizens, everyone has the possibility of challenging, both in courts, but through also administrative process and consultation, plans that are manifestly not working towards the 1.5 degrees. Okay, so some actually pretty, in some sense, optimistic things coming out of this discussion. The other point that I wanted to ask, and it's one of the bits that that actually thought was quite important in terms, I guess, of domestic potential litigation, was the fact that in a passing comment in paragraph 427 of the advisory opinion, the court said that, quote, fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies, end of quote, may constitute wrongful acts in their own right and therefore can potentially give rise to state responsibility. under international law. So I wanted to ask you your views about that, especially as someone who is not a climate lawyer. That seemed to me to be one of the most bold statements by an international court or tribunal regarding specifically fossil fuels and international law. And in practical terms, because you also come from a place of intersection between academia, practice, and activism, I wanted to ask you if you expect these passing comments to be helpful for litigation, for political mobilization against fossil fuels, for administrative processes. My question is basically, is this the big deal that I think it is?
It is, absolutely. The paragraph, of course, has already attracted wide commentary in academia and also in the media. It's a striking statement for the court to make. Of course, for climate lawyers, it's remarkable to see the court making this statement because the language around fossil fuels has been incredibly contentious in the climate negotiations. Of course, none of the treaties mentions fossil fuels, and only in recent years we've seen a few cautious pronouncements on fossil fuel phase-outs, which are all kind of phrased in very cautious terms, have been incredibly controversial, difficult to negotiate. And so the court is using very clear language here, kind of stipulating exactly what kinds of conduct could amount to internationally wrongful acts. And of course, that is also something that is remarkable, that the court speaks about internationally wrongful acts under the heading of attribution. But it's really actually here bringing in the primary norms and coming to a conclusion, which it said it was not going to do. So that's very interesting, to say the least. Yeah, I do think that this very explicit statement has immediate value in domestic litigation and potentially also litigation at other levels, because litigants no longer need to argue by analogy or deduction, but can really cite the court directly. And then at the level of negotiations, of course, it really strengthens the hand of small island states and other climate vulnerable states in negotiations over phase-out timetables and subsidy reform, etc. These issues which have been so difficult to negotiate. So hopefully it will unlock some progress there.
Dylan, are you also optimistic about that part of the opinion?
Yeah, I think it's a big deal too. It effectively puts states that continuously produce coal, oil, and gas on notice that expanding fossil fuel production comes with increased legal risk of international and domestic litigation. So with that, advocates can now make clear to these major emitting states at COP and other spaces that to avoid legal risk and litigation, they have to stop issuing new fossil fuel licenses and stop providing subsidies and adopt regulations to reduce, if not phase out, fossil fuel production. And I would also add to, I think the joint declaration of Judges Bandari and Cleveland also gives SIDS and climate activists a lot to work with in terms of how they might push the court's comment further. So in their declaration, they explicitly stated that states are obligated to take specific measures to phase out fossil fuels, including ensuring that environmental impact assessments for fossil fuel extraction projects take into account downstream combustion emissions, and also that their NDCs include plans to adopt and enforce regulations to phase out fossil fuels. So hopefully these important obligations and measures can be affirmed by other courts further down the line.
Right, exactly. Especially since Dylan and I are sitting in Australia currently, this all seems, especially because Australia has accepted the ICJ's compulsory jurisdiction, to me, it seems that a state like Australia is very much on notice, right? Including based on the fact that the court was very clear to also bracket questions of causation, right? So it said causation is important for calculating, for example, damages if you are a state that has suffered direct harm. But at the same time, it said these are obligations erga omnes, right? Every single state could potentially bring a case. And I'm not saying that states are falling over each other to bring cases against the big emitters, but I feel the court was very clear in distinguishing between um, basically violation of primary obligations and state responsibility on the one hand, and difficulties of calculating causation for the purposes of the calculation of compensation on the other. That I think, of course, if you are a state, a Pacific state, it still leaves a lot of questions unanswered. But in terms of the potential of international litigation, I think it should put states on notice that technically any state could bring a case alleging that systematic subsidies of fossil fuels are as such unlawful under international law. So my next point basically concerns the fact that this was, at least in theory, a unanimous opinion, right? And I can see how that was especially important for symbolic reasons, right? Seeing the court being so united when it comes to such an important issue like climate change. I'm saying though that this was a nominally unanimous opinion because in reality, a number of judges had serious misgivings about aspects of the advisory opinion. And in particular, Judge Yusuf described the advisory opinion as, quote, lacking concrete and tangible replies capable of engaging with their material scope. And he also said that the court's, quote, attempts to dodge, elude, and avoid by all means the ordinary meaning and material scope of question B borders on the unreal, end of quote. These are harsh words, right? This is, I would say, the vast majority of dissenting opinions do not use as harsh wording as Yusuf's supposedly not dissenting opinion did. And my question is, can you tell our listeners a little bit more about his concerns, like about his legal argument? And also, more importantly, perhaps, if you share some of his concerns.
So I think Judge Yusuf's separate opinion is a very important one. I'm personally very grateful for it because it clearly outlines some of the ways in which the opinion fell short for smaller and developing states, but also in a way illuminates the challenge and the work that needs to be done by SIDS moving forward. So just to explain a bit about his concerns with question B, the first part of question B, which specifically invited the court to address the legal consequences in respect of states, including in particular small island developing states which due to their geographical circumstances and level of development are injured or especially affected by or are particularly vulnerable to the adverse effects of climate change. And in a nutshell, the court's view was that the application of the rules of state responsibility does not differ depending on the category or status of an injured state. And so especially affected states and states that are particularly vulnerable are in principle entitled to the same remedies as other injured states. And I personally agree with Judge Yusuf's view that this particular interpretation of question B fundamentally undermined the legal relevance of the advisory opinion and was quite disappointing, especially for those who've suffered most from the effects of climate change. And I also just want to say he made a very scathing Humpty Dumpty reference that's worth checking out, and also mentioned that the court's approach reminded him of the famous remarks by Anatole France that the law and its majestic equality forbids the rich as well as the poor to sleep under bridges, to beg in the streets, and to steal bread. So, yeah, very scathing. But I think for SIDS, this really was a missed opportunity for the court to include important SIDS-specific remedies, like restitution in the form of declarations, recognizing the official, territorial, and maritime limits of SIDS, and also the continued sovereignty of SIDS, and their statehood despite the effects of climate change. So yeah, despite the big win of question B generally, I think that is the challenge for SIDS moving forward, to make clear that SIDS are owed specific remedies and forms of redress.
Fair enough. Thank you. Margaretha, what's your evaluation?
Yeah, I also very much sympathize with Judge Yusuf's concern and share it. Of course, the court left much unsaid, especially on question B, and that is the question that the climate vulnerable states cared most about, and that is Judge Yusuf very rightly stresses that. So that's it's very true what he says there, but it remains true also that the unanimity carries huge political weight. And what I know then from a very pragmatic point of view is that the court, at least on these really critical questions, does not really kind of close the space. It actually holds the space, and it seems to do that quite consciously. So when it comes to breaches, so again, the court avoids that question. You can say it dodges it, but it doesn't foreclose future arguments that are exactly about what this case was about and wanted to achieve. So in that sense, that is, I'm very grateful to the court for that level of sensibility, and optimistic about what can be done to make further headway on these really important questions. Of course, there's also a UN General Assembly resolution to be negotiated and adopted. That is also again a space where more specific conclusions can be drawn and actions can be taken. Here, Judge Bandari interestingly notes that in his view, the court should have established some kind of reparations mechanism, and or established and recognized the need for that. And now basically the ball is in the court of the General Assembly to take that action, and that would be very much in line with the mandate of the General Assembly and the court's opinion. I'm paraphrasing here, but it's worth taking a look here at what Judge Bandari said, which I thought is a very kind of practical, actionable suggestion to remedy some of these shortfalls.
That's interesting. I actually haven't read his opinion yet, so that's next one on the line. So, okay, so your point, Margaretha, if I understand it, is that, look, maybe the court didn't go as far as it could in saying helpful things, but it didn't say unhelpful things, right? And in a sense, I hear the argument that this is not to be lightly assumed when it comes to the ICJ in matters of global concern, right? We are coming from, in the longer history, for example, a destructive advisory opinion when it came to nuclear weapons in the 1990s, right? This was not it. It didn't say anything that would actually harm the climate movement, even if it doesn't necessarily always say the things that maybe we would have hoped. Speaking of things that we would have maybe hoped, one of the points that Judge Yusuf made was that the court simply repeated or summarized well-established rules of international law without much concrete analysis and application. I'm not sure that I agree with this criticism in general, but I think that it does hit the mark when it comes to international human rights law. My reading of the relevant paragraphs was that the court pretty much did repeat points already raised by other bodies, especially UN human rights bodies. I'm raising this specifically with you because human rights has been very central for advocacy, both of vulnerable groups, but also of many global South states, right? That is, human rights was an argument many global South states had in their submission. And basically, my question is, do you agree with this evaluation, or am I a little bit harsh towards the court? How do you think the court did when it comes to human rights law in particular?
Yeah, I think it's fair to say that the court's analysis of international human rights law was limited. SIDS and other developing states collectively, I think, put forward a lot of robust human rights arguments. And yes, I was disappointed that the court didn't address, for example, in a lot of detail, the importance of the right to self-determination, which is very central to the plight of Pacific and other global South states and peoples also living under colonial occupation. And I think, yeah, Vanuatu put forward very robust arguments for the court to recognize obligations to respect the right and to promote the realization of the right that weren't engaged with in the opinion. Another missed opportunity, I think, was with regard to the right to a clean, healthy, and sustainable environment, which many Pacific and other global South states provided arguments on, particularly setting out its substantive and procedural content, and also arguing its status as a norm of customary international law, which the court didn't take up. So, yes, definitely, I think space to build on.
Right. And just to explain to our listeners, perhaps who might not be as familiar with Pacific politics and history, the Pacific is home to almost half of places that are in the list of non-self-governing territories of the UN, right? And even some places that have been removed from that list, but under peculiar circumstances, for example, Hawaii, right? And the concern there by many is that the court might have said, oh, sure, of course, if you have statehood, your statehood might continue, even though it said so extremely quickly. But the question is, what about the self-determination of those peoples who remain under colonial occupation and their lands might be submerged underwater by the end of the century and they might have to leave their ancestral homelands, right? What about the self-determination of those who are not states? Right, yet, or they're not, they might never become because they want to do other things with their self-determination. So that's not a marginal issue in the Pacific, where colonialism, Western colonialism, remains a living reality for so many, right? So that's just as a matter of like context of why this is not just an academic exercise in the Pacific. Margaretha, what is your view about what the court did with human rights?
Yeah, I share your and Dylan's analysis on this point. I'm nonetheless positive, I think, because I am extremely mindful on a lot of things that the court could have said here that would have been unhelpful. And here we have incredibly progressive jurisprudence now that has come out of the Inter-American Court. And so it would have been unfortunate, to say the least, maybe disastrous, if the court would have contradicted the Inter-American Court on the substance, on any point really. That would have been just very, very unfortunate and unhelpful. And so the court, I think we can say again, held the space here, in not even space, but also you can say implicitly, not fully endorse, but certainly didn't contradict any of the progressive jurisprudence. I think it's taking note of the Inter-American's opinion, explicitly citing it, without explicitly endorsing it, but it certainly, the court had all the opportunity to express disagreement and didn't do so. So I would emphasize that. And then work with what we got. So there are a few, again, very like minute details almost in the opinion that are actually very significant, such as in the court's discussion on the territorial scope of human rights treaties. It basically, again, it doesn't express too much of an opinion because it considers it to be necessary to look at specific states, specific treaties, etc. But it does know that the jurisdictional scope of human rights treaties is not necessarily an obstacle to recognizing obligations, establishing state responsibility. And then the final sentence of that whole section is about customary international law. So noting that the scope of customary international obligation is distinct from treaties. And so what the court really says there is that these, at least that's how I like to read it, that these limitations that are so also becoming evident now in jurisprudence, such as the Agostinho case and the European Court of Human Rights, finding that case inadmissible case, at least when it with respect to the claim against states other than Portugal, right? And the claimants are Portuguese, where it's about the jurisdiction clause in the European Convention of Human Rights, saying that this clause only applies in exceptional circumstances extraterritorially, and here there's no justification essentially for extending the scope to to states other than Portugal. And so the court in that judgment recognizes that the jurisdictional scope of the European Convention is particular to the European Convention, and so differs from that of the Convention on the Rights of the Child and the Inter-American, the treaties on which the Inter-American Court relied in its advisory opinion on human rights and the environment, which had been cited by the applicants as supporting the notion that there is an extraterritorial coverage of obligations. But such a kind of restrictive reading of one treaty then means very little when you try to understand what states' obligations more broadly are substantively under international law. And again, I think that statement that the court makes there in custom really suggests that those obligations are not territorially confined in that way. And so it's a small statement, I think is very, very significant.
Right. Okay, so I think, Margaretha, you have clearly a sort of Hippocratic oath. First, do no harm when it comes to international courts and tribunals. And it sounded that they didn't. They didn't do any harm, at least when it comes to human rights law. Okay, so my final substantive question that maybe I should have even asked first, because it's almost a bad faith question. And I asked this question, I asked Juan Nauz 2 weeks ago when he came to talk about the Inter-American Court of Human Rights. So the question is this: in my view, the past 3 to 5 years, the most helpful and hopeful breakthroughs when it comes to climate change, not as a legal problem, but as a real world phenomena they come from China, right? In the form of producing very, very affordable solar panels, to a lesser extent, but also significant electric vehicles that have driven both its own extremely rapid electrification, but also that of much of the global south, right? Solar panels have suddenly become cheap. However, both in front of ITLOS and in front of the ICJ, China actually advanced very conservative arguments in regard to the role of international law when it comes to climate change. At the end of the day, though, what matters for climate change is not legal arguments, it is reduction of emissions. So my question was, in this particular context, can we say that international law, and in particular international law litigation, matters in the struggle against climate change and in the struggle for a just transition? Or if you wanted to be perhaps less cynical or less absolutist, how does it matter? If you have a state that on the one hand makes really conservative legal arguments, but in a sense, it's the reverse of what has been happening for a long time. Here we see a state that is willing to walk the walk, but not talk the talk. In that reversal, how does international law matter?
Yeah, that's a great question. And the paradox is real, of course. China's large-scale deployment of solar PV and electric vehicles has probably done more to bend the emissions curve than any judgment could. But it's also very true that before ITLOS, as well as the ICJ, its submissions were, I think, if you put it nicely, minimalist. So litigation then it cannot replace decarbonization on the ground, but it does shape incentives, to use an ugly word. So advisory opinions ultimately clarify the rules, right? And those rules in turn influence investment flows and trade policy and, you hope, state practice. So it matters not because it cuts tons of CO2 directly, but because it reallocates the kind of burden of justification, if you will. So after this opinion, it states that continue licensing new coal or subsidizing oil that must explain why such acts are lawful. But equally important is the how. So here, one of the key elements of this opinion, legally speaking, is the role of principles such as CBDR-RC, common but differentiated responsibilities and respective capabilities. And the court really makes the most of that principle. But this principle has been challenged for decades in the negotiation process and then also in the proceedings. So in both when it comes to the scope of application, and we saw the argument, it doesn't exist outside of the climate regime, and then it has been diluted essentially through the Paris Agreement, where because of the addition of these words in light of the national circumstances, the whole essentially it's so differentiated that there is no differentiation left anymore. And then also in terms of its substantive content, so the very obvious understanding, I'd say that the common but differentiated responsibility is partly about historical responsibility. Up until this point had been contested, where states made the argument it's not about historical responsibility, it's more generally about responsibility, maybe for current emissions. And so the court makes it clear that this is probably, I think the court frames it as a general principle of law, or at least it's a widely applicable principle, customary international law, but it certainly exists also outside of the treaties and an independent existence. And then in terms of its substantive content, the court also confirms very clearly and explicitly that it has everything to do with historical responsibility, as well as capacity, as well as different national circumstances. But it even explicitly kind of does away with the argument that Paris dilutes the principles, scope or content. And so that is also about justice. That is what China was after. And I think to an extent, a large extent actually, that is also justified because this is about facts, it's about science ultimately, and Judge Shui also stresses this in her opinion, and I think rightly so again. And so here China raised all of these arguments and in that sense made a constructive contribution to the proceedings and to the opinion. And so yeah, we hope then that China will also take this opinion seriously and become one of its proponents as we move to implementation.
Yeah. And I know I'm being a little bit exaggerated in the way I'm phrasing the question. I don't think it's an either or, but I think it's an interesting tension. Dylan?
Yes, I share all those great thoughts. And just to reiterate, I think that question that you asked isn't really a bad faith one. I think it's one that I'm sure every international lawyer and climate justice advocate is asking themselves and struggling with, especially at this time of ongoing genocides, where the court's rulings and advisory opinions on Palestine are being ignored and disregarded by the very same states that are major emitters, and that's no coincidence. And I just want to shout out as well the amazing work of Vanuatu and Margaretha as counsel in the recent advisory opinion, making that link between climate justice and the occupation and genocide. I think when it comes to climate change, litigation matters, but that the Pacific and the climate justice movement can't see litigation and international law as the main focus of our efforts. It's extremely limited. And as many of us know, especially us Twailers, the international law system is implicated in the climate crisis in various ways, and it's part of the problem. So it can't be seen as the main solution or way forward. And with the opinion, the court, of course, didn't say that international law is part of the problem, but it did, in its final paragraph, remind us all of the limits of international law. It said, and I quote, "International law has an important but ultimately limited role in resolving this problem, and that a lasting and satisfactory solution requires human will and wisdom at the individual, social, and political levels." So I think some might read that final paragraph as a cop-out and, maybe a shifting of responsibility to SIDS and climate vulnerable peoples. But another way of reading it is as a gentle and almost subtle way of telling the climate justice movement not to use the court and international law as an excuse not to take the big radical actions that are needed to transform the world and I think bring about whatever system of international law that world requires. And with that, I think something else I would say is that litigation matters because aside from the law and the doctrine and all of that, I think the court became useful as a very public theatre for galvanizing the movement, not only by exposing the inhumanity and the shamelessness and impunity of global North states, but also became a showcase of the great resilience and power of Indigenous peoples, particularly Indigenous youth, and yeah, really became a platform for their visions of a different world and a different type of international law, which honors their sacred relationships to their lands and waters and all living beings. So yeah, that might sound a bit too optimistic and romantic, but all
No.
the law aside, I'm personally forever changed by what Pacific students did. and what Vanuatu achieved with the ICJ opinion.
No, I think you're making a good point, and especially also the reference that you made to Palestine, right? Where again, one needs not to be naive to see that litigation has played an important role in sustaining a movement, right? It might not be implemented in a direct way, but it has helped people keep up pressure on governments and on domestic courts, etc. So to say that in climate change space there is a parallel dynamic playing out, that seems to me very realistic as an assessment. Okay, we have gone on for a very long time. In Call to the Bar, we also want to ask at least one non-law related question to show that we are well-rounded and normal humans. And this year, this season, rather, the question we are asking is, what is your favorite underrated or unfairly maligned character from basically fiction, and why does this character speak to you? Why do they move you? Why do you identify with them? Margaretha?
No, the suggestion that we identify with them makes it a little dangerous to
No.
answer the question.
Fair enough. Why do they speak to you? It doesn't need to be identified. Yes.
Yeah, so but when you mentioned an obscure character, what the character who came to my mind is Flora. Flora is the ghost of a customer in Louise Erdrich's novel The Sentence, and she haunts Tuki, the story's protagonist. When Flora was alive, she was dubbed by the employees at the bookstore where Tuki works, and that seems to be heavily inspired by a small bookstore that the author herself runs. She was dubbed their most annoying favorite customer. And but the reason why I want to say I identify with her is that it's clear that there's a kind of deeper, more serious dimension to her character, and the writer Louise Erdrich has talked about this in interviews. She says that because it's a white woman, it's an indigenous bookstore, and she really ultimately, I think, represents some of the realities of American colonialism, where
Okay.
indigenous peoples are hunted by the spirits of settlers and by a history built on extermination policies. So I very much recommend reading the full story if you haven't read this incredible novel, or anything basically that Louise Erdrich has ever written, to discover in this case how Tuki ended up handling this relationship. And I think you'll enjoy reading about it.
Thank you. Actually, that's a fantastic suggestion. Thank you, Margaretha. Dylan.
I love this question. I don't know how to answer it. The character that came to mind is from an anime show, Demon Slayer. Not too sure if you watch, but the lead character always gets a bad rep for being too optimistic and too hopeful. And yeah, the character's Tanjiro. He's been through a lot of loss, and goes through a lot during the series, but is always positive, always hyping people up, always lifting people up and bringing them together. And so, yeah, just a really cheerful guy, which I don't think people really like these days. But yeah, for me, especially just in these really dark times, characters like Tanjiro give me hope.
Thank you. These are both fantastic answers. Thank you for your time and for your generosity, and for all the work you did to bring this advisory opinion to life. And thank you to everyone for listening.
Thanks for hosting us.
Thank you so much.